Now the judges will introduce themselves.
How are you all? We're glad to see you. My name is Rita McCannon. I'm an attorney in Huntsville, Alabama, and the other judges will now tell you who they are.
Hello, everyone. My name is Thomas Mackey. I'm in the History Department at the University of Louisville and with the Brandeis School of Law at the U of L.
Hello, I'm Jay Barth. I'm the Chief Education Officer in the city of Little Rock and a retired professor at Hendrix College where I taught American politics. We're so glad to see you today and wish you good luck.
Please introduce yourselves.
Hi, we are Unit 3 from Wauwatosa West, the state champions of Wisconsin, and I'm Miles Coppage.
I'm Ellie Schultz.
I'm Ryan Reynolds.
I'm Savannah Williams.
And I'm Jenna Bokenhauer, and we're here on behalf of our teaching assistants, mentors, and teacher, Mr. Chad Mateski. And my Zoom isn't letting me change my name, so sorry about that, but my name's Jenna, so.
All right. Jenna, we'll try to remember and not call you Nora.
Okay.
Are we all ready to begin? You all take a deep breath and I'll read the question. Unit 3. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? We look forward to hearing from you.
James Madison wrote in Federalist 39 that the Supreme Court would decide disputes between the state and federal government. His prediction was right. The courts had had a significant impact on federalism throughout history through the exercise of judicial review. Our panel agrees that the practice has drastically expanded federal power while limiting state autonomy.
The Supreme Court solidified judicial review in 1803 in Marbury v. Madison, which began the increase of the power of the federal government. In the early 1800s, the Supreme Court increased federal power through judicial review in cases such as Gibbons v. Ogden and McCulloch v. Maryland, which broadly interpreted Congress's power under the Commerce Clause and Necessary and Proper Clause, respectively.
Following the Civil War, the Supreme Court's interpretation of the Due Process Clause in the 14th Amendment created the doctrines of incorporation and substantive due process, fundamentally altering the structure of federalism. The first substantive due process case was Lochner v. New York in 1905, allowing the federal government to recognize natural rights not specified in the Constitution. The first incorporation case was Gitlow v. New York in 1925, incorporating the First Amendment rights of free speech and press onto the state.
When the Supreme Court struck down New Deal legislation in the 1930s, President Franklin Roosevelt threatened to pack the court and tell the switch in time that saved 9 in West Coast Hotel v. Parrish. During the New Deal era, the Supreme Court would continue to expand federal power through cases such as Wickard v. Filburn, which dramatically broadened the interpretation of the Commerce Clause. Though historically, the court has expanded federal power, we recognize in the past 25 years, the court has used judicial review to limit federal power, beginning with cases such as U.S. v. Lopez, which limited the reach of the Commerce Clause, and Prince v. U.S., which limited the reach of the Necessary and Proper Clause.
We agree that the practice of judicial review is counter-majoritarian, yet it is beneficial to a democratic republic. The judicial appointment process laid out in Article 2, Section 2, Clause 2 is inherently counter-majoritarian, as judges are not elected by the people, but rather appointed and confirmed by politicians. However, counter-majoritarianism serves to check tyranny of the majority, which is essential to a functioning democratic republic, particularly in a Madisonian democracy. Aristotle recognized the benefits of an aristocracy, in which virtuous rule by individuals of the highest order is best suited to establish policy. Though our federal courts do not establish policy, judicial review allows them to interpret the constitutionality of legislation, which in turn affects policy.
The founders' study of the failures of direct democracy in ancient Athens taught the importance of limiting the majority. Vanderbilt law professor Susanna Sherry recognized the importance of a counter-majoritarian Supreme Court when she discussed the importance of lifetime judicial appointments, allowing them to better protect rights free from the wrath of the majority.
As a panel, we would not place any additional limits on judicial review, as we believe the current limitations are sufficient. The case and controversy clause requires cases to be brought to federal courts, limiting their jurisdiction and prohibiting advisory opinions. As Hamilton explained in Federalist 78, the Supreme Court has no influence over either the sword or the purse, limiting the impact of judicial review. This can be seen in President Andrew Jackson's disregard in Worcester v. Georgia and the enforcement of the Indian Removal Act.
Amendments ratified through Article 5 can overturn Supreme Court decisions, as seen with the ratification of the 13th Amendment overturning Dred Scott v. Sanford. Moreover, the federal courts limit themselves. In Baker v. Carr, the Supreme Court ruled that the federal courts should not deal directly with issues the Constitution lays out for Congress, enhancing the political question doctrine.
The judiciary was created with the intention of interpreting the Constitution and the constitutionality of law. Judicial review is a crucial check on the majority's ability to pass unconstitutional laws. As Chief Justice John Marshall stated in Marbury v. Madison, it is emphatically the province and duty of the judicial department to say what the law is. This concludes our statement. We are now ready for your follow-up.
Thank you so much. Professor Mackey, you want to go?
Sure. Let me jump in here. Now, I'm a little fuzzy. You're talking about this unelected, unaccountable Supreme Court and federal judiciary more generally, perhaps. And yet I thought this was a political democracy where majorities are supposed to set public policy and supposed to govern. So I'm still a little fuzzy on this relationship between what political majorities that are elected democratically can somehow be checked by these 9 old people in robes in Washington, D.C. Help me out understand that.
Well, as laid out in Article 3, Section 1, the court is inherently counter-majoritarian because of the founders' knowledge of their study of ancient Athens. And this is important because at the time of the decision in Loving v. Virginia, 72% of the country was against interracial marriage, but the court's function as a counter-majoritarian branch was able to protect this right, though the majority of the country did not agree with it.
Article 3, Section 1 states that the justices will hold office during good behavior and life tenure. And the framers of the Constitution, particularly Alexander Hamilton, understood the importance of keeping well-educated justices to prevent tyranny of the majority. And while ultimately they do check the legislative body that represents the people, they may also rule in favor of the people, seen in Justice Marshall's dissent in Milliken v. Bradley, which he states that the decision was based more on a perceived public mood and not a neutral principle of law.
Although it's also important to recognize that the courts do act with the majority whenever they strike down something in conflict with the Constitution. This can be seen in Bowling v. Sharp, where they struck down Washington, D.C.'s segregation in public schools through reverse incorporation.
You can also see tyranny of the majority in where the majority is infringing on the rights of the minority. And we can see this in the case Lawrence v. Texas, dealing with the same-sex marriage, and that only 32% supported this.
I believe my colleague Jenna was referring to sodomy in the case Lawrence v. Texas.
So Savannah, you mentioned some areas where the court has restrained itself in terms of the types of cases it will not take on and not review. Could you talk a little bit more about that and whether you think that the court has generally gotten it right or wrong in terms of those topics or areas of the law where they're not going to take that step?
One place where we see the court not taking the step into an area of law is when they provide deference to administrative agencies. This was established in the case Chevron USA, the National Resource Defense Council. And essentially it stated that the Supreme Court understood the complexity of issues that administrative agencies dealt with. So they wanted to understand the administrative agency's interpretation of the law.
The Supreme Court you have to have case and controversy, and the defendant has to show that they have some sort of standing and have suffered some sort of legal harm. This can be seen in Dred Scott v. Stanford, where their standing was in question as the federal courts held that former slaves lacked U.S. citizenship.
The courts led themselves with the doctrine of strict necessity, where when they rule on cases, they only rule on issues they deem necessary. This can be seen with the court case Rescue Army v. Municipal Court, where they didn't rule on certain issues because they seem too abstract for them to rule on.
Courts can also place many other limits on themselves, and we can see this with mootness and ripeness, showing that the court either decides on a case too early or too late. And a case where we can see this is the case Poe v. Ullman.
Change gears with you just a minute. There is a senator who has written a book called One Vote Away, claiming that changing one single Supreme Court justice can change history. Do you all agree with that? Disagree? Tell me why.
I agree with this because from 2005 to 2019, an average of 15 cases were decided on a vote of 5-4 on the Supreme Court. So this shows that many detrimental cases are decided by a vote of 5-4, and changing this would affect almost 1/6 of the Supreme Court cases that are heard each year.
Additionally, I do agree with that book, considering that the Senate, particularly the Republicans, were so against President Obama's nomination at the end of his term of a new Supreme Court justice. And even when he did nominate liberal siding Elena Kagan over following Justice John Paul Stevens, the opposing party was very angered at this.
I would also agree with my colleague Miles in that we should actually have a supermajority where cases or in decisions won't be as close. And we can see this in the case Citizens versus FEC, where I believe that the case, the decision was very close. And so having a supermajority where it's not like that would help to solve the issue.
I do agree with this, although I would not say that we should pack the courts. I say that we should bring more diversity onto the courts on all bases, both apolitically and politically. I align myself with Justice Elena Kagan when she said we look at institutions and see people who look like this and who we believe share the same set of values. And when this occurs, people feel more comfortable.
I disagree with what the book has to say about that because of parties only really want the courts to be packed when their legislation is not being passed. We see this when President Biden was a senator. He said that the idea of packing courts was a bonehead idea. However, now being president and head of the Democratic Party, he does agree with packing the courts because he wants legislation to be passed.
So doesn't this then lead to the argument that the Supreme Court is just another field for politics, no different from the House, the Senate, or the states? How would you respond?
I would respond by aligning myself with Senator Ted Cruz, who supported an amendment that would set the number of justices on the Supreme Court at 9. Many times throughout history, the Judiciary Act, such as the Judiciary Act of 1869, has either expanded the number of justices on the court or lowered the number of justices on the court in order to expand political power and gain. However, if they were limited by an amendment, the Judiciary Act would not be able to overturn that amendment, considering the amendment process is under the Constitution and is the supreme law of the land.
The Supreme Court is not supposed to be a representative body, so I believe packing the courts would be a negative action, as if we pack the courts to 13, what's stopping us from packing it to 400 or 435 or even 535 and making it more than the House of the Representatives, which is supposed to be representative of the people.
Good timing. Y'all, you finished right as she held up her stop sign. You all not only were well prepared, but you were on overdrive with every answer. I had trouble keeping up because you knew so much. The one thing that I would ask, and this is not meant to be so hypercritical, but I'll just say it. You have so many cases that you were mentioning that you didn't leave yourself an opportunity to tell us what those cases were about. You put them with the idea that came from their decision, but you didn't really have time to talk about what they were about. And sometimes that leaves us as breathless as you. So I would just ask in the future that you maybe have a few less cases and a little more discussion of those cases.
I totally agree with that. I think there are times when less is more by focusing on a few fewer cases and concepts, but going a little deeper actually shows more knowledge. And I think y'all clearly know a lot, but I think you could have actually shown even more sophisticated understanding of these concepts by taking a little bit more time and going a little bit deeper. So that would be my one critique moving forward.
Oh my word, you guys know stuff. Boy, do you know stuff, and you know stuff, and you want us to know that you know stuff. And that's what they're saying. Sometimes it seemed like an avalanche of stuff. Now, these are big, hard topics: judicial review, federalism, counter-majoritarianism, states, Congress, the federal court, Supreme Court all deal with these, and they're struggling with these. There are no answers over the past 200 plus years. So of course we ask high school students to explain them to us. So it's an impossible question, but I thought you did a really fine job in covering the waterfront and demonstrating to us the breadth and depth of reading that you did have. When you're trying to make a point, sometimes you want less, but make the point in a more sophisticated, deeper manner, but less string of cases and more. That's what my colleagues are saying. But pretty impressive, folks. Nicely done.
Thank you so
Thank
much.
you.
Good job.
Yeah.
Thank
Yeah.
you.
Breathe. It's okay now.
Thanks for spending time with us.
Thank you so much.
Bye-bye.
Bye.